Hello, this is Michael Tableson. I am a partner at Husch Blackwell's Employee Benefits Practice here in the Milwaukee office, although it's a national practice. We're excited to talk to you today and to give today's presentation on ensuring your 403B plan is in compliance. Before we begin, I'd like to cover just a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. Just going to take a few seconds to highlight a few of these icons. First, if you have any questions during the webcast, please submit your question via the question box. We'll try to answer all questions during the webcast, but if a fuller answer is needed or if we run out of time, it'll be answered later via email. There's also an icon to assist with your viewing preferences. Accordingly, please note you can expand your slide area by clicking on the maximize icon on the right side of the slider by dragging the bottom right corner of the slide area. If you have any technical difficulty, click on the help icon. It has a question mark, provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for continuing legal ed credit in Colorado, Illinois, Indiana, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. All right, with that, I will quickly introduce my co-presenter, Jack Keller. Jack is a Vice President and Senior Consultant for CBiz Retirement Plan Services, where he leads the higher ed and 403B teams in the Midwest region. With that, Jack, I think we'll kick this off, and just so you can see today's topics. Last year, by the way, we did just a deep dive in common plan problems and solutions. This year, it's a more general overview, as you can see. We're going to hit an overview of ERISA fiduciary responsibilities, establishing a prudent fiduciary process. We're going to give some updates in higher ed and talk a little bit probably at the end here, if we can get to it, about consortiums and MEPs, multiple employer plans. So starting with the overview of fiduciary responsibilities. All right. The eternal question, who is a fiduciary? Are you walking and quacking like a fiduciary? There you go. You might just be a fiduciary if you're a person who exercises any discretionary authority or control over a plan or its assets. You render advice to a plan for a fee. That's more likely going to be your service providers. Or you're responsible, either personally or as part of a committee, for oversight and administration of a plan. Okay. There is something called the exclusive benefit rule that applies to you if you are an ERISA fiduciary. And what that requires is that you act in the best interest of participants. In fact, not only that, you have a duty to act exclusively in the interest of participants and beneficiaries in your fiduciary actions. This is distinguishable from actions taken as a plan sponsor. And then in and amongst those, ERISA obligations are to be prudent and fair. Okay. A kind of fundamental issue here is your plan governed by ERISA? And the easiest way generally to think about that is, look, if you're making employer contributions and you're a non-governmental plan, you're not a church plan, you're not a plan sponsored by a church that hasn't elected to opt out of its exemption, you have ERISA status, although to keep in mind, as we've noted here, that non-ERISA plans and fiduciaries are going to be subject to very similar obligations under state law, and in fact, the case law typically in this arena will work by analogy to ERISA. All right, what types of people at the institution are very likely going to be fiduciaries? Well, it's based upon how they act and sometimes based upon the documentation. The ultimate fiduciary is going to be the plan sponsor. There's going to be delegation of that responsibility to a president, not my preference in general, VP finance or other finance officer, controller, HR director, or HR professional, benefits, staff, any of these people individually or as members of a retirement plan committee, somebody who acts to appoint these people. Board members are very likely to be found to be fiduciaries. There's a note here that the definition of fiduciary is not based on your job title. They are, in fact, separate responsibilities, although sometimes based on governing documents, somebody will be a plan fiduciary ex officio. That means by virtue of their job. But again, that's not a matter of law. That's something that you set up. That's something that you'll have in all your legal carpentry in this regard. Jack, do you want to jump in here?
Absolutely. Thank you, Michael. Our next section is going to get into establishing prudent fiduciary processes. But before we get into that, it's a best practice to have a process in place for these 6 key areas of risk. So you see them on the slide here: fees and expenses, investments, participants, compliance, record keeper oversight, and fiduciary governance. And we'll get into the details of each in the next section. But the potential benefits of managing these key risk areas are at the bottom there. Reduced institutional risk, reduced administrative burden, time and expense, improved investment opportunities, really an improved employee appreciation of the benefits, and ultimately enhanced retirement outcomes. We're going to dive into the next section here about establishing your prudent fiduciary processes, and I'm going to actually hand it back over to our ERISA attorney to speak about the fiduciary governance part of this.
It's always handy to have your ERISA attorney with you at all times, in my opinion. Okay, what is this all about? You'll see here that fiduciary conduct will not be evaluated based solely on your outcome. It depends in large measure on your process. So what I'm a big fan of is a well-documented, prudent process. Let's just look at this. Delegate responsibility. Hang on. So fine. What you're going to want to do, and I might actually just move ahead here to the next slide quickly. Basically, what you're going to want to set up here is a process that's well documented. Like I said, you're going to have some sort of corporate action that's going to show the creation of a committee or the delegation of fiduciary responsibility. I'm a big fan of express documentation, appointing the committee members, and you'll note here that there's a charter. I'm a huge fan of the charters because they clearly delineate the responsibility for what the committee is intended to do and not do. So, sorry, that took a second to pop up here. You'll see there the committee charter. I like these documents to be clear as to scope of authority. It'll talk generally about the composition of the committee. But on the other hand, what you don't want to do with any of these things, and it also goes for the investment policy statement in particular, is to overpromise or be terribly detailed as to the types of determinations that will be made, or that, for example, specific investment funds. Oh, one last acknowledgement on my part, that the acknowledgement of committee acceptance is also handy to have on file. It makes it clear when people are individually stepping into these roles, and again, I'm going to reiterate this point, I have found over 30 years of doing this approximately that a lot of individuals don't understand that when they're on a committee, they are not doing their day job. They're not the controller or CFO on that day. They're wearing a different hat. They're wearing a planned fiduciary hat. So it's really nice to have this acceptance and also a document that isn't on here, which would be a resignation or withdrawal document. That's another good thing. Again, we want the timing and scope of everybody's responsibility to be completely clear. Jack, I think we'll move on to investments.
All right. Thank you, Michael. And next key area is the investment work. And as a fiduciary, you are responsible for the selection, monitoring, and replacement of investments. And you must perform due diligence and capture your investment process in writing. And fiduciaries are actually held to the prudent expert standard, which is really the highest standard in law. So we're going to get into the next slide, some 4 pillars of a sound investment process, and we'll get into the details in subsequent slides. But number 1, investment menus should be built for the masses and prioritize simplicity while still offering a wide variety. Lots of people want to ask what the appropriate number is, and we'll give you an idea of what that is next. Plans should offer a mix of actively managed and passively managed index funds, and maybe include some target date or risk-based investment options. Investment management costs can detract from long-term performance and should be minimized to the extent possible. A great client that I work with that says that's the one guarantee there is in investing. If you invest in the cheaper share class, your performance is going to be that much better. And investment managers should be evaluated over full market cycles. Despite recent volatility, we're still in a 9-year bull market, and so everybody's 5-year numbers look pretty good, but we want to look over that 10, 15-year full market cycle.
Hey, Jack, before you continue talking about this specifically, back to a fundamental principle, I was somewhat surprised a number of years ago when I was meeting with a committee and the general counsel of the company who was of the organization who was on the committee expressed surprise that he and the committee also in general were fiduciaries and being held responsible for the choices they were giving the participants. Because he said, well, it's the participants who make the choice. It's like, yeah, but they're picking among the menu that you've given them. It's just astounding to me. But I guess it does not go without saying that everything you described.
No, absolutely, and we'll get into some ERISA litigation later and how maybe too much choice was thrown at certain plan participants. But really, that feeds us into our next slide, and that has to do with some analysis paralysis. And so, research. This is research from Columbia University. And it's that participation drops as the number of investment options increases. There's a small percentage of participants that really have good investment knowledge, that want to build their own asset allocations and pick their own funds and manage these themselves. But most employees not only want to be told how much to save, but also where to invest. And that's why we bring in some broadly diversified options, fill out the major Morningstar style boxes, but we don't want to offer, for instance, 5 different bond funds in a plan. Rather than having one individual build their own bond allocation, let's just pick a broadly diversified, maybe Vanguard or American Funds bond fund where those investment managers can pick and really select the different sectors of the bond market and companies or municipalities to invest in. So, a suggested approach here is maybe 10 to 15 investment options are the right amount, and that really counts the target date or risk-based series just as one choice. All right, next slide has to do with, again, participants not wanting the pressure of actively manage their own retirement portfolio. We're huge fans of target date funds. They provide an easy-to-use outsourced solution to participants, and these are the funds where, as the investor gets older, his or her investment profile changes. So these funds are rebalanced and reallocated automatically. It's a set-it-and-forget-it strategy that gives exposure to different asset classes, to different companies, and again, they're really managed by the experts. Takes into account time horizons. Some also take into account the risk tolerance as really critical factors. So a suggested approach here, and many plan sponsors utilize these as maybe the default fund for automatic enrollment. But target date funds do reallocate, and that glide path changes over time. And so we think those are maybe better than just the risk-based funds, because I may be an aggressive investor now, but unless I go in and change it myself and become a conservative investor later, that's not really done for me. One helpful tip here, and I know I'm going to get some eye rolls from everybody who has really stressful jobs across the way, but people that work in higher education actually tend to live longer. And so you may want to pick a fund that minimizes longevity risk, and that's the risk of outliving your money. So some target date fund managers will actually continue to manage these assets. The glide path goes into, and they're managed really through the retirement years, where it's an active rebalancing and real allocation to like age 90 or 95.
Maybe it just feels like they're living longer, Jack.
That maybe the days are longer. That's right. That's right.
Okay.
Minimizing investment management expenses. Research indicates that the investment or the expense ratio is the most proven predictor of future fund results. This comes from Morningstar, and you never want to overweight past performance and try to chase returns. So the suggested approach here is to minimize the investment management expenses, but also consider other factors. A helpful tip is just to ask your advisor or ask your service providers or record keepers if a cheaper share class is available. I'm referring again to the ERISA litigation we're going to get into later, but use the institutional buying power of your large plans and get a cheaper share class.
Absolutely an extremely common failure. I have this come up on I got to imagine you see this on a regular basis as well, and it's an easy claim for plaintiffs.
It is, and another piece of that. And I know Michael was just telling me before we got started that he got a question about this morning, but that's revenue sharing, and it's not on the slide here, but revenue sharing is really the excess revenue or expense that is collected through the funds in the plan to help offset administrative plan expenses. And I've seen pretty frequently that depending on which funds plan participants invest in, they actually pay an unequal or unlevel amount of plan expenses just based on the funds they choose from. And I know that's a huge area that Michael can help with, and that we can also work with, and that gets into kind of bundled fee arrangements where the plan fiduciaries don't really understand the fees that they're paying. So a suggested approach again. Yeah, you're right, because it doesn't show up as an itemized expense. It's just bundled in the fund.
Something I've often heard. Yep, it's all free. Isn't this free?
Yeah. Yeah, and then we unbundle it, really reduce the fees, but then participants tend to have all sorts of questions because now the fees are transparent and they're equal. Again, Michael talked about documenting your process, and documenting what you've gone through for this example is key. But utilizing institutional share classes and full fee transparency is certainly a fiduciary best practice.
And in that transparency, good communications, and I think that would probably be where CBIZ would come in assisting you with communicating with participants. so they understand they're not more.
Yeah, I mean, one of the things, and we can even partner with Michael or anyone else to provide what we would call fiduciary training and some investment training to committees who may not be comfortable with this, but help to educate committees and fiduciaries on terms like revenue sharing and share class and fee transparency.
All right. Well, I just moved the slide ahead, Jack, just to briefly touch on 321s versus 338s, if that's okay.
Sure. And go ahead.
I was just going to mention the distinction here between an advisor that provides advice to a committee that's making these determinations versus an advisor to whom that responsibility has been delegated. And Jack, you can talk a bit about this, about how you feel about this and how this has worked with CBIZ's clients. I would just like to throw in an admonition that I have found, I mean, certainly the 321 model, the advisor to the committee is more common. 338s become more popular. Or more prevalent. I have clients who candidly just can't delegate enough time to this. They don't have people who can take the time to do the work to make these decisions, for whom the 338 is definitely the better choice. But just to point out that it's not a magic bullet. There's still an obligation. The buck stops with the fiduciaries at the company and with the company to make a prudent choice of this advisor and to have some level of reasonable oversight. Jack, do you have any insights on?
I like to point out it's really the third row down and the fifth row down. So who has discretionary authority over investment decisions with 321 versus the 338. And then the fifth row down gets into what you were talking about. Does the retirement plan committee maintain fiduciary liability associated with the selection of the advisor? And it's yes in both cases. And I'm just going to bring up just a couple of things on this slide. Higher education tends to be a little more parental. And so really the committee wants a seat at the table to represent their plan participants. And so in the past, most of our arrangements are 321 arrangements. I'll tell you, with CBIZ, we can work in either capacity, and really we do the same work in either capacity. Our recommendations, our due diligence don't change. We have one committee that says, I'd rather, in our review meetings, I'd rather spend 10 minutes going through the investments. You tell us what you're going to do, and let's focus on issues like compliance and governance and our participant services. Because this CFO tends to think that's where the committee's attention ought to be focused. So that's just one case. But I will say this is really an evolving topic, and we're seeing more and more 338 inquiries across both the 401k and 403b market. Certainly, if anybody has questions, I know this can be kind of confusing, but again, I think you have access to these slides, and you can follow up with any questions.
I will mention also, Jack, in the typical 321 scenario, I have found committees on the opposite end of the spectrum from what you described as just getting entirely bogged down in the nits and gnats and details of the investments, where I think they lose track of the bigger picture.
There are lots of actively managed versus passively managed debates in those committee meetings, and those are good conversations to have. But you're right, the conversation, the process does get a little bit bogged down, and it is way more streamlined under the 338 arrangement.
Yeah,
where we really do our work. We come in and present it to the committee, and like I said, then the bulk of the meeting can be spent more on what's best for the participants and compliance issues and things like that.
You want to move ahead with the fee and expense discussion, John?
Yep. Next risk area, fee and expense. And this is another rapidly evolving subject. You don't have to have the lowest fees, but your fees need to be reasonable. Excessive fees can have a big impact on participants' investments. And, how do we determine reasonableness? It just means, a reasonable price for the services received and, being able to benchmark and negotiate and understand what your fees are. So there are a number of different fees and expenses associated with these retirement plans. There's audit fees, there's legal fees, there's investment fees, education, advice, record keeping. And how do we aggregate all these and understand or compare to what's out there? And there's a couple of different ways that we can do that, and that's what we're really going to get into in the next slides. And really an RFI, what we would call a request for information, a formal RFP, some sort of a benchmarking, and then the negotiation. And really what I'll say before we dive into these is, the folks that are on this call or that may be fiduciaries or are on retirement plan committees, unless it's a really large institution or organization, most CFOs, HR directors tend to wear multiple hats, and so they have more responsibilities than just the retirement plan oversight. And so they tend to rely on outside experts like advisors or their service providers to help them with this. And we would highly encourage you all to do so. Some challenges, actually this next slide really gets into it, really a lack of historical data. Many of these plans weren't subject to ERISA about 10 years ago, and so they really didn't do these types of reviews. Small budgets, limited administrative capacity as far as time and expense, and they've really never done this before. They don't really know, they just may not be experts. And so one option, we're going to get into a couple of different ways to do this, but one option is just a blind request for information. And this is where, the plan sponsor would remain anonymous. If it were CBIZ, for instance, we'd reach out on ABC Institution's behalf without sharing their name and just request pricing and services from 2 to 3 alternative service providers. The plan sponsor is under no obligation to change record keepers. You can keep the plan as is. You can negotiate better pricing with your current record keepers, or you can switch record keepers. And what I would say here is just ask the question to your service providers. From a fee and expense perspective, it's a really competitive marketplace right now for record keeping services. And if you don't know how to ask the questions or don't know how to negotiate, have somebody ask on your behalf, because 9 times out of 10, if you just ask the question or provide an alternative that would offer lower fees, the incumbent's usually going to match that. This process, the RFI process, we recommend doing maybe every 3 to 5 years.
Right. And actually, before you go on, I want to come back to a fundamental concept that you alluded to, Jack, which is this, you may not be an expert. Now, the concern with that is, of course, that's the standard, somebody who basically is an expert in this area that the Department of Labor is going to hold you to if you're a fiduciary. But the way to satisfy that basically you've been talking about, Jack, is to employ appropriate experts, people who have the expertise to assist you in this, because ultimately that's what you need to do. If you're left in a position of having to defend what's happened in the course of a Department of Labor exam, or even in a worst case scenario, a less good scenario, if not the worst, a lawsuit in this regard.
Yeah, I actually think that that really gets into the next slide, Michael. Producing a formal RFP. And if an institution were to be an expert and really wanted to complete this on their own, it's a pretty lengthy process, and it can take a lot of time and and a lot of expense away from the institution. And then, if you go out to 5 to 10 different service providers and you get back 5 to 10 100-page proposals from all these different service providers, it gets back to that analysis paralysis and almost nothing is done. And so if you leverage maybe an outside party to do this for you, for instance, the plan sponsor is not allowed to be contacted. All the communication is really gone through the consultant or service provider that would help in this circumstance, to where it's really only a couple of meetings and decisions that really need to be made by the institution. So with a formal RFP process, you would share some plan data and intelligence just to see what competitors would charge. Maybe see what their services look like, what their technology website looks like, what do the participant services look like, are there any proprietary fund requirements out there? Again, the plan sponsor is under no commitment to change record keepers, but this is the more formal process of going through this, to where maybe there are finalist presentations where the committee would hear a pitch from some alternative service providers, and the plan is out to market. This is a more formal, lengthy process. We recommend doing this every 5 to 7 years. All right, the next way to do this is just benchmarking your plan. And this is where you would kind of survey the data that's available out in the marketplace, maybe contact some of your peer institutions of similar size to see what their fees are, see if your fees are similar, and also, look at proprietary databases out there. I mean, I know there are service providers that will provide this information, this benchmarking information, for free. The Profit Sharing Council of America has some publicly available databases out there. Consultants, advisors certainly have their own proprietary databases of plans. But benchmarking the plan, that's something that ought to be done every year.
Absolutely.
Just as part of your due diligence process and documentation, like Michael said.
By the way, talk about documentation and process. I'm a big fan of a fiduciary calendar. In other words, you set up a calendar for the committee of tasks that need to be done and when they need to be done, and then somebody who is the chair of the committee, or basically acting in that role. It's not something you and I had talked about when we were working on this, Jack, but I like it. And then over the course of the year, you check it off or note that it was done and when or by whom, and then the chair of the committee signs off at the end of the year, and you tuck it in the record.
Yeah, that's actually, Michael, you stole the slide from me, but that's the last slide in this section after we talk about negotiation. That's the documentation of the process and that feedback loop that we talked about earlier. Maybe an annual or quarterly summarization of the work that's been done to the committee, up the food chain to the president of the board. All right. Well, we've gone through really 3 of these critical areas: governance, investments, and fees and expenses. And now Michael's going to jump in here to talk about some industry updates and the recent ERISA litigation.
All right. Again, I'm just going to cover this fairly quickly because this could be the topic of an hour-long session easily. But to date, what we've seen is over 20 lawsuits in this arena involving the administration and investment of 403B plans in the higher ed space. These are the types of claims that we've typically seen, not necessarily in order of priority, but excessive fees. There are going to be some themes here. The non-institutional share classes, the the shares are more expensive than they should be for what's available. You're not leveraging your buying power in the plan. The plan is based on passive rather than active investment. Jack, I think there's, I really do think there are arguments on either side of that. Just generally underperforming assets. This issue of the inefficiency of multiple record keepers, I think that's a little bit archaic. I think the industry, I think higher ed is generally moving away from that. Is that consistent with what you've seen, Jack? I think there's been more consolidation and streamlining.
Yep. And even in some of the other not-for-profit markets like K-12, for instance, there have just been some nightmare stories about there. And really the point there is with multiple record keepers, Michael, the different record keepers are really competing for plan assets, and so it's more of a sales-driven process than it is an education-driven process to the participants. And that's where, again, that analysis paralysis gets into the equation. But certainly having, just the best practice is having a single record keeper with an open architecture investment menu. So there's really no overlap there. And that's where there's a real separation from the service provider and then the fund managers. Right.
And then moving along here, prohibited transactions, effectively that the sponsor of the plan or the plan fiduciaries are acting, it's usually more the sponsor in this regard, are acting in their own interest rather than the interest of the plan, and effectively are violating ERISA and Internal Revenue Code rules on the use of plan assets, which can lead to excise taxes and reporting. If not potentially, if they're severe enough, the loss of the tax status of the plan, which, even though these are exempt orgs, could be very harming to the plan participants. Breaches of duties of loyalty and prudence, and asset-based fees. This gets back to the reasonableness of fees, because fees start to grow. The argument would be much more rapidly and inappropriately, not commensurately with the value of the actual service to the plan. And then how is it that revenue sharing is used appropriately? Just want to note that there's activity on this in the last few years. Notably, there was a settlement from the University of Chicago on some claims to the extent of $6.5 million. Actually, some very recent settlements, although the formal settlements aren't available yet, from Duke University, both on claims regarding how the revenue sharing was used and whether or not fees were excessive in the plan. There have been some dismissals. Some of these cases they're just hard to make out that it's not reasonable what the employer is doing. So UPenn, Northwestern, WashU, and an outright, trial victory where NYU had to go to trial. Now, based on what I've read, although I haven't seen it, the plaintiff's counsel has filed an appeal in the NYU case. All right, so questions that you might be asking. Is this something that you need to be worried about? It's something that's worth reviewing and considering, and being very intentional about. It's a good time always a good time now to review what processes you have in place. What are you doing to limit liability? By the way, I am going to mention in here also, in terms of legal framework and carpentry and what you have in place, take a look at what you have in terms of protection for your committee members, what's appropriate in terms of indemnifications, and do you have separate fiduciary coverage, which is something entirely different from your fidelity coverage. So, have you reviewed your plan, fees, and expenses, very much along the lines that Jack was talking about? Document. Papering this over or documenting it after the fact is nowhere near as persuasive. And we want that documentation to be carefully done. It needs to kind of be it's a Goldilocks thing. You want just the right amount, not too much, not too little. How do you get leverage, obviously, from advisors like CBIZ or from legal counsel? And what are you doing to protect investments? So, in terms of an action plan for a prudent process, Jack, were you going to run through that?
Yeah, I can run through this, and this is just kind of a review of what we've talked about. But yeah, this is just a 9-step action plan for a prudent fiduciary process. So Michael started this off. Delegate important roles and responsibilities. Establish a former committee charter and maybe even provide some fiduciary training to the committee so they understand what being a fiduciary really is. Get your documentation.
I'm a big fan of quarterly fiduciary education, but it should be at least annual.
Yeah, and ongoing. You're right, because regulatory and compliance, legislative changes. The fiduciary rule, for instance, is something that's come up this year. Have your documents in order, your charter, which really defines the roles and responsibilities, and establish and maintain the investment policy statement. The investment policy statement ought to be consistent with the work that's actually being done. So if your IPS says one thing, but maybe your advisor or service provider is executing on something else, then those aren't consistent. So you want to maintain and continue to review that IPS. And Michael said it earlier, but we prefer more qualitative language rather than a bunch of hard numbers, percentile rankings that you need to follow there. More about process and using words like periodically rather than quarterly.
Because otherwise you get hanged with what you've written.
And
you're going to be held to the standard of that IPS. You're going to be held to what you're supposed to be responsible for, not only under the law, but under your charter. And, by the way, as noted here in this step 6, not only the law, but your plan document. So make sure that comports with your practice.
Yeah, and I would even jump back to the charter, Michael. I've seen it where, maybe the charter lists the committee members, but a committee member misses frequent committee meetings, and maybe the charter IPS says they must be there each time, but he or she hasn't attended for full year. So again, keeping that language looser and having people on the committee that are consistently going to be there and be actively involved in discussions. As we jump, I found a way to.
Jack, pardon me. I'm sorry to jump in on you. I apologize, but one way I found to deal with that is to have delegates or alternates called for in the charter and appointed by the committee members, because I've had I was working with one that was a $3.1 billion fund involving multiple internationally owned companies, and the individuals were coming in and out of the country. So they had they would have a delegate, an alternate who would come in for them and keep them apprised of what's going on.
Well, that's good. I do like that. Performing the due diligence on your investments, your service providers, your advisor, maintaining compliance with the plan document, document your decisions. One thing we've recently, for some of our institutions that we work with, we'll actually take the meeting minutes for them, or we can provide our minutes and then they can put into their own template. But rather than saying this was discussed and that was decided, using the actual committee members' names in the minutes will actually show that there's been an active discussion in these committee meetings. So Tim brought up this idea, or John, asked a question about participant education. The previous minutes were put up for approval by Ann. So showing that
Right.
interaction on the committee.
I absolutely agree. The only admonition I have on that is you don't want to write a book. That's why I'm a great fan of having them reviewed, either it's Jack or it's legal counsel. I'm personally a fan of legal counsel in this regard, because you want to have just enough to absolutely establish a prudent process, but you would be surprised at what people document in the minutes. Because oftentimes there's a note taker who's being very diligent about recording everything that happened. And some of that detail might not be as helpful later, and certainly not necessary.
All right. No, that's good. So yeah, benchmarking and then summarizing communication to the board. And I think Michael helped me out a great deal there. But that's the action plan. It can look different than that, but that's just something that we've put together, the both of us.
Jack, you want to do a quick job of just running, in the interest of time, running through the participant slides, maximizing participant outcomes, for instance?
Yep. Yeah, I'm gonna move through this pretty quickly, but our next area is participant education and advice. So, how do we maximize participant outcomes? That's the whole point of offering these plans. A lot of institutions offer a very generous, rich plan. And so what steps can we take to ensure a financially secure retirement for our plan participants? Now, different features to consider. There are annuity platforms out there, both individual and group. There are mutual fund platforms out there. And we'll get into some detail in subsequent slides, but, plan design, we're big fans of auto-enrollment, even auto-escalation, and using the target date fund as the default fund. That's the QDIA, the Qualified Default Investment Alternative. Participant education and resources, one-on-one consultations and group meetings, providing as much of those opportunities to your employees that you can. A lot of times smaller plans maybe don't get the attention that larger plans get, and so you may need to utilize an outside party for help with that. And then income replacement tools. We've seen some record keepers or service providers have really great tools on their website to where I've got this chunk of money. I've got $800,000 saved in my 403B plan, but what does it really mean? So based on like your age, your asset allocation, your savings rate, it spits out an algorithm that says this is what your monthly paycheck will look like in retirement. And if you like that number, if you don't like that number, it's pretty easy to make some changes to either your allocations or save more. But there's some really great tools on the website. We'll talk about financial wellness. We'll talk about behavioral finance and what we can understand about your plan participants and maybe target some campaigns to make them, more successful. I'm going to fly through these next couple of slides, but, how often do you evaluate your plan health? Are you tracking these trends over time? So what's your participation rate? What's the average deferral rate? What's the average account balance? Now, we certainly think it's the best practice to look at these on an annual basis and see if the numbers are trending up or trending down, what the overall plan health looks like, and make some changes to either your communication or your education efforts. And you can even target maybe some undersavers through this. And I know different record keepers have tools. Certainly CBIZ and other advisors out there have tools like this to help. Just a couple of statistics. This one is about 403B plans. So, and this data is from 2017, meaning it's probably 2016 data from the Plan Sponsor Council of America. But 21% of 403B plans now automatically enroll their participants. 34% automatically enroll participants at a rate higher than 3. And really, the problem with enrolling them at 3 is then they stick there for too long, and maybe 10 years go by and they haven't made any changes. So auto escalation is a feature that's kind of new that we're liking, and that's where that percentage is upped maybe 1-2% each year. So you're enrolled at 3, next year it's 4, 5, 6, each year all the way up to maybe 10 or something like that. Some 401k statistics just really emphasize that 403b plans, continue to lag. So 33% versus 21% use auto-enroll. Plans that utilize automatic enrollment have an 87% participation rate. So I said earlier, participants want to be told how much to save. And, a lot of committees tend to think that they're being too hands-on by pushing them into this plan, but 87%, only 13% of people opt out of that. Plans without automatic enrollment, their participation rate was closer to 50%, and then you can see the savings rate down at the bottom there, how it's increased in the last 10 years. And, we tell people, strive for 10, maybe up to 15% is what you're going to need to save, kind of depending on what your what the plan sponsor match or contribution looks like. And just one note here, a lot of, and I'm going to talk maybe private institutions have offered in the past just a set percentage of pay where there's no employee responsibility, no matching concept. It's just, hey, we'll put 10% into the plan. You don't have to contribute anything. We're seeing more plan sponsors review that and say, put a little more emphasis on the employees to make it more of like a matching program so that they will save more. That the institution may continue to put in as much. Of course, if budgets are tight, you can revise that. But that just puts more emphasis on them to save more and will ultimately drive up their savings rates and make them more successful. Next slide, HSAs are something that can be communicated along with the 401k to kind of aggregate all the benefits and savings. Financial wellness, there's actually an arrow on the side there that's not showing up. But just a couple of statistics when it comes to financial wellness. It really has a great impact on employee success, but it also can have an impact on the employer's bottom line. And employer health care costs associated with employees who used financial wellness programs actually decreased by 4.5%, while those who did not participate, their health care costs increased by 19.4%. And that's what's not showing up on the right there. But you can see at the bottom there that for every employee who delays retirement for financial reasons, employer costs increase $10,000 to $50,000, and sometimes that's per year. Wellness programs, companies can see reductions in absenteeism, turnover, and employee stress, and companies that implement wellness have a 28% reduction in sick leave, 26% reduction in medical costs, 19% reduction in absenteeism, and fewer sick days. So we've heard a lot about wellness from a kind of health insurance perspective, but I could be the healthiest guy in the world, but if I'm financially stressed and I haven't saved enough or my personal balance sheet's out of whack, I spend I think on average 3 to 5 hours per week at work employees spend worrying about their finances. And so this is where I'm saying this can even become like a profit center for the institution to implement some of these. And your service providers, I know lots of the big players out there have financial wellness programs, and also advisors out there have some tools too. So flew through the participant part of it, very important. I'm going to hand it off to Michael on this compliance slide because he really knows what questions the Department of Labor is going to ask during an audit process.
Thanks, Jack. Actually, it's not only the Department of Labor; it's the Internal Revenue Service, and this is where, again, now we're talking about the non-public organizations in terms of the Department of Labor under ERISA, but even for those public organizations, the tax status of the plan is dependent upon compliance with this myriad of complex rules. As I mentioned at the beginning, last year we did a 50-minute to an hour deep dive just on this topic alone. And I was working with a record keeper from CBiz, and what she did is she laid out these types of common issues, and you can see there are 8 of them here. And what she did is talked about what she'd observed, and I talked about how to fix it. But I guess what it comes down to is you'll have this, you can look at this, you can think about this, you can basically do what amounts to a self-audit. And I think it's well worth it. Run yourself through this or get some help to run through this. And if you do find that there are failures in these or other administrative type areas, that's where you can work with me, or you work with your lawyer or other advisor to make corrections, and then depending on the circumstances, you might need to file those corrections with the Internal Revenue Service under a program called the Employee Plan Compliance Resolution System, EPCRS. It grew up over the last 30 years while I've been doing this. When I started, it was the Wild Wild West. We would reach closing agreements, but now you can go in and be proactive and file your proposed correction and limit the exposure of the organization and the plan to just the cost of fixing it and some relatively nominal fee to the IRS for approval. And I think that's really all we need to cover in this regard. If somebody has a more specific issue that they want to discuss, certainly you can contact one of us and we can talk it through as to what might be appropriate. Jack, did you want to just take a minute and talk about MEPS?
Sure. And I'm sorry to skip over that slide because compliance is a critically important area. So like I said, any questions, Michael or I can help. But MEPS consortiums, it's another recent trend. And the biggest takeaway here is at the bottom of this slide. And the Trump administration has really shown kind of a willingness to open up MEPS and make them more flexible. This is just an area where CBiz can help institutions maybe look at exploring these types of opportunities. So the next slide here, MEPS are achieved when multiple employers join together to offer a single plan to their different members. And really the key for MEPS is like administrative efficiencies. So it's really kind of a single 5,500. A lot of the administrative stuff is done the same. A consortium association is really utilizing the buying power. So each institution would continue to offer their own plan, but they leverage their own buying power to maybe decrease costs from record keepers or service providers. And certainly we're seeing a lot at maybe like the state level association plan, or even like in a religious affiliation for some of these plans, developing a consortium. Some MEP considerations here, just some pros and cons. Like I said, I mean, one takeaway is in the past, if one of the member plans of the MEPs was out of compliance, it could potentially disqualify the whole plan. Again, the Trump administration is saying that may not be the case anymore. So just something that's in vogue out there. We have kind of an action plan here for a MEP review process. But again, kind of like the last question or the last section, if anybody has questions on this specific issue, we're happy to help. I know we're coming up on.
And we're coming up on the hour, and we have about half a dozen or so questions queued up. Jack, do you mind if I'm just going to hit them real fast with you?
Sure.
The first one's a little bit hard to answer very concisely about, is there more detail on universal availability? In fact, there are actually some recent guidance issued on some exceptions to the universal availability rule. That might be one we need to do some follow-up after the fact, maybe with an email, lay out some more guidelines, unless you have something concise you can deliver on that, Jack.
No, I think that's probably a follow-up question. The next one, a Roth plan option, it's not required. but certainly, we think it's a good thing to offer, especially to younger employees. It's really just like amending your plan document and just putting in another salary deferral code into your systems. So
correct. It's a design option. It's not a legal obligation. As to, can you define what a record keeper is? Basically, it's somebody you hire by contract who's not necessarily and typically not a plan fiduciary. It's somebody that keeps the records of the plan. Oftentimes that gets a little commingled, if you will. It gets kind of mixed up with other functions like custody of plan assets, but it can be separate and distinct. It's basically a third party, somebody outside your institution who is keeping the records of the plan, doing the statements.
That's what I would say. The statements, the website, a lot of times non-discrimination testing. I mean,
correct.
That's typically who the record keepers are like. It's like Fidelity, it's TIAA, it's T. Rowe Price, Vanguard, and it's
where again that gets confusing. A lot of these also have their own funds, but that's separate. It's a separate function.
Correct. And then the advisor would a lot of times be separate from that record keeper to minimize any conflict of interest.
Right. And the advisor is going to be a fiduciary typically, whether or not they think they are. They typically are.
That's a good point. Typically, the record keeper is not a fiduciary. That's a great point.
Yep. And then in terms of the investment fees, Jack was talking about this earlier in terms of benchmarking. There are either services like FBI that you can use, or Jack was saying a lot of the advisors have their own proprietary database. Jack, don't you have a database on 403Bs that you use?
For the benchmarking question, I will follow up with that individual. That's just a little more complex than what we have here. And then really the last question that's on there is 321 versus 338 at a high level. So under a 321 capacity, and again, this is the advisor. The advisor is really like a what's called a co-fiduciary, where, and I'm just going to use CBIZ because that's who I work for, but we would conduct our due diligence and provide our recommendations to the committee. But it's ultimately up to the committee to implement any types of fund changes that we present to them. So we're a co-fiduciary along with the committee, but the actual decision lies with the committee. At a 338, CBIZ would become like an investment manager, to where we bring our due diligence to the table and we would tell the committee, this is what we're going to do with the investments. And the committee can't say, no. So they've really outsourced all the fiduciary roles to us, minimized their liability in regard to the investments. But what Michael was saying is they still have a responsibility in both cases, the committee does, to oversee and make sure the advisor is appropriate.
Right. There was a new question, Jack, that just came in at 1 o'clock regarding the obligations of non-ERISA plans, regarding providing written, notices annually. Here's the thing. ERISA was actually written in some ways to protect plan fiduciaries by creating one overarching consistent set of rules rather than having to deal with the rules and regulators of every state and local state courts and laws. However, what you'll find is now, even in these non-ERISA situations where there are claims made under state fiduciary concepts, you'll see a lot of borrowing from ERISA. So if you really want to be safe in administering these plans, you should use as guideposts the ERISA obligations for disclosure. You're not going to have the same federal reporting obligations. Those are two aspects under ERISA that are confused, reporting to the government versus disclosure to participants. And that's what we're talking about here. And those disclosure obligations should probably be viewed, from the lens of what would you have to do if you were an ERISA fiduciary. Anything to add to that, Jack?
Nope, that is your area of expertise and very, very well worded, I would say.
Thank you. I'm all over that. I've been in and out of those cases for years.
Yeah.
And I think that's the last one we have. It looks like we do have a little follow-up on just a couple of items that we'll do more individually. However, I do thank everybody who's joined us and stuck with us. And as I inadvertently noted, most of you are still here, and that's fantastic. So thank you again. Again, as I mentioned, last year was a deep dive in a single topic, not a simple topic, but a single topic. And this year we provided a very broad view of these plans and your obligations under these plans, and we hope it was helpful for you and your organization. And thank you so much. And thank you, Jack.
Thank you. Yeah, thanks, Michael.